Members, it's time for us to start our meeting, and we've also formed a quorum. We'll first invite the government representatives to come in.
First
of all, I'd like to welcome the government representatives for attending this meeting. You've already got the name list, so I won't introduce them one by one. At the last meeting of the Bills Committee, we continued to do clause-by-clause scrutiny for this property management services bill. At the meeting on the 8th of June this year, members raised certain concerns. Would you please read paper 1788 bracket 01 for the items for follow-up action? The government has provided a response in Chinese, paper 1788 bracket 02. Perhaps I should first invite Mr. Franco Kwok to brief us on the reply. Thank you, Mr. Chairman. Members, concerning concerns raised by members at the meeting on the 8th of June and at previous meetings, we've already submitted a written reply to you through the Secretariat. There are a few items to answer. First of all, about the licensing rules for Class 1 property managers. On the direction and major principles, we're of the view that education qualifications, years of experience, professional qualifications, and whether or not the person is a fit and proper person should be the four major concerns. To address members' concerns, at previous meetings, we met with these sectors. And as regards the licensing criteria for this class of property managers, we've set out the requirements in paragraph 2 of the paper now, which are agreed to by the sectors. In 2011, the Home Affairs Department set up a consultative committee including members from the professional bodies related to property management. Understanding is that 14 training programs have been recognized. In 2014-15, the number of students will be about 680. The details of the programs had already been set out in the annex to the paper. Last time, members asked about the number of property management companies. At the moment, there are no laws to require for the registration of property management companies, so we don't have the exact numbers. According to previous consultancy reports, in the market there are around 800 such companies. 300 are big ones. They are the corporate members and their associates of the trade association. The remaining 500 are smaller ones. The principle that we always abide by is that we shouldn't have unnecessary hurdles for those who would like to enter the property management market. There should be freedom of joining the trade. In terms of regulation, there are licensing criteria for property management. As the regulatory authority has not yet been set up, we cannot assess the number of property management companies. But in future, when we issue licenses, we'll consider the criteria concerned and take into account the views of the industry. As regards remuneration for members of the regulatory authority, many statutory bodies and committees also offer remuneration to their members. For empowering provisions, the CE will, in accordance with actual circumstances, consider whether or not to provide a remuneration. There are individual pieces of legislation for different regulatory bodies, but remuneration is not always offered. The original legislative intent is that under this bill, we should provide an enabling provision to empower the CE to offer symbolic remuneration to the members. Last time, members were concerned about the word remuneration. We would give consideration up to other pieces of legislation to amend Schedule 3, to see whether or not we should retain the word remuneration. And then the next concern is about Section 6 of Schedule 3. The purpose of this section is that when the chairperson cannot exercise his responsibilities temporarily, after considering members' views at the last meeting, we agree that even if the chairperson is temporarily absent from Hong Kong, he can, through telephone calls, teleconferences, etc., conduct meetings. We agree with the DOJ that we should amend the bill to empower the vice chairperson to, in accordance with actual circumstances, when the chairperson is temporarily absent from Hong Kong, to take care of the duties of the chairperson temporarily. At the last meeting, members also asked about the judgments of the disciplinary committee. Section 3 of the bill specifies that there should be a register with personal and corporate convictions concerned with in relation to criminal offences, and this register should be made known to the public for perusal. Licensing records and penalty as a result of disciplinary offences should be recorded. It is also provided in the bill that an annual report should be compiled by the authority with the description, executive summaries, and all proceedings of appeal. We also took reference to other relevant regulatory bodies and actual arrangements of implementation. Other regulatory authorities do not make public such records for public approval or perusal, The present arrangement already allows members of the public to know the judgments of the disciplinary committee or the appeal tribunal of the PMSA. Therefore, for the request to make public all those records will be passed to the future authority for consideration. Thank you.
Thank you, Mr. Kwok. Members, do you have any questions? Ms. Claudia Mo. Thank you. Regarding for public inspection of the register, so you say that you're already satisfied with the current operation, but there are requests. There are such requests, and you promise to refer such requests to the future authority for its consideration. Why can't you consider doing it now? And there are about 800 PMSAs in Hong Kong, PMGs in Hong Kong, and there are 300 of them, which is big. I'd like to know whether the big PMCs are all related, associated with property developers. Are you sure that there is fair competition in this sector? Regarding publishing the judgments, well, as I said in the paper, our practice is consistent with other regulators. And we've set out in the bill that there are venues for the public to check a report containing the outline of investigations, summary of complaints received, and also an outline of all proceedings. Members asked for the whole judgment to be published. We do not see a similar practice in other regulators. So I suggest that we follow the practice of other regulators. And if members asked for such information to be further published, we will leave it for the future authority to decide. Regarding the number of such PMCs, as I said, we don't have any registration system. Some larger companies may be of bigger scale, but we have no information on their their association with property developers. For larger PMCs, they may be managing more residential developments and may be related to some large residential developments, but their association with individual developers, we don't have such information. Now, for other regulators, according to you, for other regulators, they do not provide such information to the public, and you want to follow that current practice. But that doesn't mean that it is correct. In particular, we are talking about our own dwellings and matters related to our own property management. Why must we follow the current practice? As far as I know, for more critical cases, there is the opportunity for members to check. But last time, members asked for the full report and the full records for them to be uploaded to the relevant website for public information. Well, professionals may be more concerned with the whole proceedings, and members of the public may just be concerned with the general outline of the case. I understand that last time we said that some professions might be affected and they would like to have a better understanding of these cases. So what is the current state of disclosure? Chairman, your understanding is correct. We have set out in the bill that for cases that have been heard by the disciplinary board or appeals committee, an outline of the case and a summary and outline of the proceedings will be available either in the annual report or in the register. This is in line with the practice of other regulators. But the issue was raised last time that from a professional point of view, people might want to understand the arguments better. But that doesn't mean that the relevant professionals cannot obtain such information from the authority when needed. As regards the access of information by the public, such information is available in the annual report or in the register. This may be even more important to the public because for a member of the public, if they just read the judgment, they may not grasp the case. But a summary or the outline will enable the public to better understand the considerations by the relevant board. Thank you. You said that the information is relatively simple and more easily comprehensible. Well, I have reservation about this. If I need a very detailed record of the case and you give me just a very simple summary, can I obtain such information using the code on access to information? Do you need the question to be repeated? Chairman, we will provide a reply later. Why? Is it a very complicated question? You talk about the legal aspect. I have to understand with the law draftsman whether the code on access to information can cope with this. But it's quite clear that for cases of concern to the general public, the information is available from the annual report or the register. But for cases perhaps it would even be more difficult for ordinary members of the public to understand the full set of records. So the question is how a person can have access to the full proceedings and considerations or judgment by the appeal tribunal or the disciplinary board. Well, I hope the administration can provide a detailed reply to Ms. Claudia Mo's question. So any further question on the administration's response, Mr. Guahim? I tend to agree with you, Chairman. I think it is good enough if a summary is provided. And for details referred to by Ms. Claudia Mo, we should see whether it is available under another piece of legislation. I hope relevant information can be given to us by the administration to let us understand the situation. Now, because if all cases are presented in full, members of the public may not be interested in reading all the nitty-gritty. Any follow-up question on the administration's reply, please? If not, let's continue with our clause-by-clause scrutiny of the bill. We completed clauses 47 and 48 of Part 7 and also Schedule 3 clauses 1 to 22. Can the administration continue to explain Section 23 of Schedule 3 to us? Is paper CB 2856, that's the Chinese text, English text C2857. Thank you, Chairman. Clause 23 sets out the details on how the authority may establish committees. Subsection 1, the authority may establish a standing committee for hearing disciplinary matters under Part 5 of this ordinance. And the authority may also establish one or more than one committee, whether not as a standing committee. A, to advise the authority on any matters within the scope of the authority's functions that the authority refers to it, and B, to perform any functions of the authority that the authority delegates to it. And every member of a committee is to be appointed by the authority. And a committee must consist of at least 3 members. A committee may include members who are not members of the authority, but for a standing committee, a majority of the members must be members of the authority. The chairperson of a committee must be a member of the authority. When the authority establishes a committee, it must specify in writing the terms of reference of the committee. The authority may, by written notice, amend the terms of reference of a committee. Subject to any directions that may be given by the authority, a committee may regulate its own procedure, including the determination of its quorum. Thank you. Members, do you have any questions on Section 23? Mr. Guahim. Thank you. So the authority may establish one or more than one committee with at least 3 members. And the majority of the membership must be members of the authority. What about the chairman? Must he be a member of the authority? Please refer to subsection 6. It is said that the chairperson of a committee must be a member of the authority. Where? Section 23(6). Oh, that's right. Thank you. Legal advisor. I've got 2 points. First, 23(1). The Chinese says disciplinary matters under Part 5 of the ordinance. It says in Chinese 違紀事宜, whereas in Part 5 it is said 紀律事宜. The two Chinese characters are different. We will consider amending the Chinese version of Section 23(1) to 紀律事宜 to make it tally with the wording in Part 5. And subsection 9, the authority or the committee may regulate its own procedure, including the determination of its quorum, subject to any direction that may be given by the authority. But please refer to Clause 46 in the Principal Ordinance. Clause 46 is about a disclosure of conflict of interest. Disclosure of interest. 2 to 3 are about proceedings of meetings that include registering the interests already disclosed and whether the chairman can continue to chair meeting. I think it would be clearer if we say subject to Section 46 be added to subsection 9 here. Yes? Mr. Kwok, are you going to respond? Thank you, Chairman. In 46, subsection 9, we have included already member, any committee under the authority. So I don't think it is necessary to amend section 23(9) here. But for clause 46(9), subsections 1, 2, 3, and 8 apply to a member of a committee, when in fact subsections 2 and 3 do not just regulate the members but the procedure. So would it be better if you make reference to 46(9) in your part about procedure? Mr. Kwok, thank you. Thank you, legal advisor, for your comment. We will further consider it. Thank you. Mr. Kwok Him. Yes, I believe the administration should consider the legal advisor's suggestion because you can be more comprehensive by amending it in this way, and that would not affect your drafting in section or clause 46. What about the chairman? What about the casting vote? Or whether the chairman can have any casting vote? Mr. Kwok.
Thank you, Mr. Chairman. In general, for Schedule 3, Part 4, where? Schedule 3, where? Part 4. Part 4, about meetings. The chairperson can cast a casting vote. Such a provision will apply to committee meetings. There will be rules to set out the details of meeting arrangements, but a casting vote can be cast. Sorry, I cannot follow you. Where? Schedule 3. Which page? Which page mentions this issue? Part 4? No. Chinese version, page C2846. English version 2847. Section 11. Where in section 11? About casting vote. Bracket 2. Subsection 2. Any follow-up? All right. If you think this can cover the scenario that I mentioned, then all right. Well, this is clarified that the chairperson can cast a casting vote if there's a tie. So you won't prescribe whether or not there should be a supporting or dissenting vote. This is casting vote here. I asked whether the chairperson is bound to cast a supporting vote or a dissenting vote. As far as I can read here, the chairperson can support or oppose the motion. Yes, Mr. Ib is correct. In law, there's no rule to specify that the chairperson must cast a particular vote, a particular type of vote. Ms. Claudia Mo, what about this presiding member? Does he have a swing vote? Mr. Kwok, can you repeat yourself? Well, basically, at a meeting, the chairperson can cast an ordinary vote, a deliberative vote. But when there's a tie, he can also cast a casting vote. But in law, this casting vote can be a supportive one or an objecting one. Ms. Claudia Mo, well, I'll be quick. Just now, the advice of our legal advisor is very good. He asked about coverage. I hope the government officials will not give a very short and simple answer. No, not necessary. I think you should go back and think about this. At least you should promise us to go back and examine it. Well, he made that promise already. Maybe you can repeat your answer again. Thank you, Ms. Mo, for your question. In my second reply, I said that we would further consider the advice of your legal advisor. Mr. Chairman, I really have to clarify. Yes, in the first time, the government official said it would not be necessary. It's only when Ip Kok Him asked the question again, he promised to go back and examine the issue. I think that attitude is not good enough. I just want to show my appreciation for the advice of our legal advisor. Mr. Kwok, any supplement? Well, we've heard your legal advisor as well as your members. We'll further consider your views. Yes, we'll further consider your views. Mr. Ip Kok Him, well, Mr. Chairman, I don't mind the style of answering. Well, after listening to members' views, they can change their mind and go back to consider our views. It doesn't matter. Mr. Lam, just now Ms. Claudia Mo asked about the Code of Access to Information. The authority is not covered by the Code of Access to Information because it's not a government department. All right. Any more questions from members? If not, we can go back to the principal ordinance. I think it is Clause 49. Members, would you please go to Clause 49? It's page C2819. Mr. Wong, would you please continue? Part 8 of the bill is about levy. Clause 49 is about the interpretation of Part 8. In Part 8, transferee in relation to a leviable instrument means the person to whom the immovable property concerned is transferred or in whom the immovable property concerned is vested under the instrument. Conveyance on sale has the meaning given by Section 2(1) of the Stamp Duty Ordinance. Collector means the collector of stamp revenue appointed under Section 3 of the Stamp Duty Ordinance. Leviable instrument means an instrument for which a levy is payable under Section 51(1). Payment period in relation to the levy payable for a leviable instrument means the period within which the levy is payable under Section 52(3). Members, Clause 49 about interpretation of Part 8. Any questions? No? So Mr. Wong, please continue. Clause 50 is about the application of Part 8. This part applies to a conveyance on sale of immovable property. Yes, please continue. Clause 51 is about leviable instruments. Clause 1. A levy of the prescribed amount is payable for an instrument that is A. a conveyance on sale, and B. chargeable with stamp duty under head 1, bracket 1 in the first schedule to the Stamp Duty Ordinance. Subsection 2. A question as to whether or not an instrument falls within the description of subsection 1A and B is to be determined in accordance with the Stamp Duty Ordinance, Cap 117. Members, any follow-up on Clause 51? No? Then, Mr. Wong, please continue. Clause 52 specifies that the transferee under a leviable instrument is liable to pay the levy payable for the instrument. For the purposes of subsection 1, if there is more than one transferee under the instrument, the transferees are jointly and severally liable to pay the levy. The levy is payable within 30 days after the instrument is executed. Members, any follow-up on this clause? Mr. Wu Chi-wai? Thank you, Chairman. A very simple inquiry. For this levy, if it is a transference of the property title from one company to another, then this provision won't apply, right? Mr. Chairman, whatever the form of transfer, so long as it is a sales instrument, the levy is payable. Mr. Wu Chi-wai, well, maybe I didn't ask my question clearly. If the property is held by a company, and within that company, there is an internal transfer of shareholdings, will the levy be payable? Well, that means the genuine holder of the property is changed. Well, according to this provision on payment of levy, whatever type of transfer it is, so long as there is a transfer, then under the Stamp Duty Ordinance, if the levy is payable, then the levy has to be paid. That is our requirement. It's the same as the payment of stamp duty. Well, maybe this is not a direct answer to your question, Mr. Wu Chi-wai. Legal advisor, can you help? Can you clarify? Can you supplement? Well, maybe there's no property transfer instrument. But in actual fact, as I said, the actual property owner or title owner may have changed by way of stockholding changes within the company. So, on the levy of stamp duty for property title transfer, the party concerned may not necessarily have to pay the stamp duty. Well, we have special stamp duties. Will those be some other considerations? So can we have some legal interpretation? Legal advisor, can you help? Thank you, Chairman. According to the provision here, for 51(1)(b), well, A, a conveyance on sale, and then B, chargeable with stamp duty under Head 1.1 in the first schedule to the Stamp Duty Ordinance. When I read the first schedule of Stamp Duty Ordinance, under Head 1.1 is an immovable property in Hong Kong, a conveyance of that. So this is a handling of an immovable property, not the shares of a company. So, for a conveyance on sale, a stamp duty will be payable. So it depends on whether or not the instrument is related to the sale of immovable property. Mr. Wu Chi-wai, is your question answered? Probably this will involve individual cases and the provisions thereunder. I think we all understand that if you sell and buy properties in the name of a company, then purely by way of shareholding changes within the company, then probably 51 will not apply because that will be internal shareholding changes. Theoretically, you should write the provisions in a clearer manner, such that you can have cross-references among the different pieces of legislation. I'm not trying to criticize you. I believe all these information should be clearly recorded. Of course, my understanding is that such transfers should also observe Stamp Duty Ordinance, Cap 117. My understanding is that for this bill, a levy is to be imposed. In principle, we should follow the Stamp Duty Ordinance. Mr. Kwok, perhaps you can clarify. Well, Mr. Chairman, your understanding is correct. This levy regime will follow the existing regime under the Stamp Duty Ordinance. That is, if a stamp duty is payable, this levy will also be payable. So we won't make special arrangements because of this bill. So we'll follow the arrangements under the Stamp Duty Ordinance. Any more follow-up? No? Mr. Wong, please continue then. Thank you, Chairman. Clause 53 of the bill provides that the levy is to be collected by the following parties. A, by the authority, or B, for the authority by first, the collector, or second, any assistant collector appointed under Section 3 of the Stamp Duty Ordinance, Cap 117, and authorized in writing by the collector. Subsection 2, the levy collected does not form part of the general revenue. Members, any follow-up questions?
I think this clause is very clear. The levy is to be paid to the authority. But the authority has got its own account. Why do we need 1B? Why should it be collected on behalf of the authority? Mr. Kwok. Regarding the mechanism of the levy collection, we propose that the lawyer of the buyer should pay this levy to the lawyer of the counterparty in a transaction, so that there is no need to make a separate payment to the authority. However, we have to authorize the collector of stamp duty to collect this on behalf of the authority. So it is just an authorizing provision. I have no follow-up. Mr. Wong, please continue. Thank you. Clause 54 of the bill. Agreement for collection and transmission of levy. 1. The authority and the collector may enter into any agreement for A. the collection by the collector of the levy for the authority, and B. the transmission by the collector of the levy to the authority. 2. An agreement entered into under subsection 1 is not subsidiary legislation. Any question, please? Mr. Wu Chi-wai. Just an inquiry. I'd like to know whether 1A and B together will form the agreement, or will there be anything extra? The agreement will be entered into for 1A and B, and the detailed arrangements will be covered in the agreement itself. Do you have any sample of similar agreements between a department and the collector for reference? Because I think 1A and B will form the content of the agreement. So the collector will collect the levy on behalf of the authority, and the money will then be transmitted by the collector to the authority. Is there any sample agreement for our reference? Well, this is a rather new arrangement. We do not have any reference, any similar agreements for your reference. But as Mr. Wu said, there will of course be details on the operation of the agreement. Well, I'm afraid that since this is a new arrangement, I would like to understand, because I think there are many similar authorization for collection of a levy or a fee. Why have you gone for a new arrangement here? Why don't you follow the previous practice? Mr. Kwok, do you have other precedent? Chairman, as far as I know, there is no other regulator that authorizes the collector to collect levy on his behalf. Of course, in between departments, there might be many arrangements, but this arrangement whereby a levy is collected through a government department, well, this is something new. Do you mean that usually the payer has to pay to the relevant statutory body directly? Is this the prevailing practice? Mr. Kwok. Now, because this is a levy system, and I think this arrangement is the first of its kind. Mr. Wu. Yes, if this is a levy, why have you gone for an agreement? The wording itself is okay. The agreement, of course, cannot replace 45(1)(a) and (b) here. Well, even without that agreement, the practice will just be the same. So why do you need this agreement? Will the agreement covers operational administrative arrangements such as the timing for collection of the levy and transmission of the levy? Because the spirit itself is very clear under Clause 53. Mr. Wu is concerned as to whether the agreement will cover a lot of other things, and things that are in matters in principle. Your understanding is correct, Mr. Chairman. 53 is an authorizing provision as regards when the levy collector should be transmitted to the authority, and the mode of transmission, the account for the levy to be deposited into. Well, such operational details would be written into the agreement. So the agreement will only deal with the operational details and not other things of principle. Legal advisor. The word used in 54(1) is may. The two may enter into an agreement. Does that mean that clause 53 alone is sufficient? And there is no need for 54 for transmission of the levy. Mr. Kwok. I'll have a go and I'll see whether the law draftsmen have anything to add. Of course, the two may enter into an agreement. And the power for the director to collect the levy on behalf of the authority can be seen in 53(1)(b). Whether an agreement is needed will be subject to negotiations between the authority and the collector. Legal advisor. If the word may is used, that means it is not necessary for two parties to enter into agreement. What about they have something like a memorandum exchanged through email? Would that be okay? Is my understanding correct? Mr. Lam, if I may try to explain. Now, this is an empowering clause. By using the word may, the two may enter into an agreement because the authority is not a government body. To protect the interests of both parties, it is a normal channel for the two to enter into an agreement. But we are not mandating it. We just give them the power. We empower the two parties to do this. No more follow-up from the legal advisor. Mr. Wu? Is my understanding correct? With or without clause 54, clause authorization under clause 53 is really sufficient for the collector to collect the levy on behalf of the authority for transmission to the letter. I'd just like to know whether there is any difference by having clause 54. Now, if you ask the two to enter into an agreement, there would of course be an agreement, and it will be based on clause 53. I see no big harm in having clause 54 here, but if clause 54 doesn't make a difference, then why do we need it? I'm not opposing it, but I just like to know what is the difference. Well, clause 53 already allows the collector to collect the levy on behalf of the authority. Why do we need clause 54? My understanding is it will provide for more clarity and give more protection to the authority. Mr. Kwok, can you please supplement? Yes, the authority is a body corporate. It can, of course, enter into any agreement or contract. This is one of the functions of the authority. As said by the chairman, clause 54 here on collection and transmission of levy will give clearer black and white legal backing for the two to enter into agreement. That will add to the safeguards for the two departments. Any follow-up? No. Then, Mr. Wong, please continue. Thank you. Clause 55. If the levy payable for a leviable instrument is not paid within the payment period, the authority may, without limiting any other remedy of the authority for recovering the levy, A, impose a penalty for the failure to pay the levy, and B, issue a certificate certifying that 1, the levy and penalty is due and payable to the authority, and 2, the person named on the certificate is liable to pay the levy and penalty. The certificate must bear the name of the Chief Executive Officer and is valid if the name of the Chief Executive Officer is printed or signed on it. The authority must serve a copy of the certificate on the person affected by the certificate. A copy of the certificate may be served on a person either personally or by being delivered at or sent by post to the person's last known postal address or place of abode, business, or employment. If a copy of the certificate is sent by post, it is presumed, unless the contrary is proved, to have been served on the day after the day on which it would have been received in the ordinary course by post. Any follow-up, please? Mr. You've got him. Of course, it's okay for the certificate, a copy of the certificate, to be served personally on the person. But if it is sent to the last known postal address or place of abode, business, or employment of the person, if the person claims that he has never received such a copy, will there be any legal consequence? For instance, can he use it as an excuse or a defense for not having received a copy of the certificate? 5 says that if a copy of the certificate is sent by post, it is presumed to have been served on the day after the day on which it would have been received in the country. But you say here, unless the contrary is proved. How can the contrary be proved? If, for instance, the address is wrong. So the postal address is wrong or wrongly written? Okay, I'll think about this. Because it's very likely that a person can claim that he has never received a copy of the certificate. Will it be by a registered mail? When the authority sends out a copy of the certificate, there will be a record. Or will it be sent by registered mail? Because you don't mention registered mail here. Well, registered mail is one way, but a recorded mail is also one way to record, to register that is already being recorded. What about there is a postal failure? What if the letter is lost? Then you have to prove that the letter is lost in the process. Then this is so difficult. How can you prove that if the person insists that he has never received it? Mr. Kwok, please supplement. When we deal with the guest house ordinance, for important matters, we usually send out by registered mail to avoid the scenario referred to by Mr. Yip or our law draftsman. That is, the person claims that the letter is lost, is not received it. But if there is a postal record, it can be used as evidence in court.
So we recommend that this be adopted in future. Will you write into this bill that registered post should be used? Because here you only say by post, sent by post. Will you consider changing this to registered post? This is not the first time we asked about this. This controversy emerged in the past as well when we scrutinized other pieces of legislation. You shouldn't leave a loophole here. Because if you only say by post, my worry may happen. Well, yes, some people may evade the receipt of the item. Well, in fact, this expression is used in many other pieces of legislation. We also took reference to other laws like the Inland Revenue Ordinance. If we use by registered post, it will be a further step taken without the actual effect. Well, Mr. Ip is saying why you sound a bit more lenient here. Why only by post is required? Why not by registered post? Yes, Mr. Chairman, that's my worry. I don't agree that by post alone is clear enough. I think you should do justice to the other party. Well, there's no basis for any argument. You say that you've sent it by post, but the other party say that he has not received it. Well, sometimes they even prescribe that the item should actually be delivered into the mailbox inside the building concerned. Well, I've heard Mr. Ip's concern. We'll go back and consider whether we need to further clarify this in this bill. We'll also refer to other pieces of legislation. Mr. Wu Chi-wai, I'd like to go to 55 bracket 2. The name of the Chief Executive Officer. Well, the authority is empowered to appoint the CEO. When money collection is involved, if only by law this person is empowered, will it be enough? Do you need to include this in the interpretation of the CEO, that is the CEO appointed by the authority? Of course, the CEO is defined right at the very beginning of the bill. That is on page 2728. Well, yes, Mr. Chairman, you are correct. We have defined the CEO at the very beginning. Well, please do not misunderstand me. Understand that, well, I think it is clause 48, if I remember correctly. Sorry, it should be clause 47. The authority may delegate its powers to the Chief Executive Officer. So I believe this CEO is the CEO in clause 55. If that is the case, should this not be included in the interpretation clause? That is, this CEO is the CEO representing the authority in exercising its powers in clause 47. Well, the interpretation of the CEO is given at the beginning. Yes, Mr. Chairman, in clause 2, the interpretation clause, the Chief Executive Officer means the Chief Executive Officer of the authority appointed under Section 7(1)(a) of Schedule 3. Yes, is on page C2729 of the Blue Bill. Well, it's for the authority to follow up on the penalty. For collection, the authority is responsible for pursuing collection. For 55(1)(a), impose a penalty. Is this penalty to be determined by the authority? Well, the penalty is spelled out in clause 56. If within a certain period of time the penalty is not paid, then of course a fine will have to be imposed. Well, if the person still does not pay it, the authority can resort to civil lawsuit to pursue the levy, or the title deed can be charged. Members, any more questions? If not, Mr. Wong, please continue. Thank you, Chairman. Clause 56 is about penalty. For the purposes of Section 55(1)(a), the transferee under the relevant leviable instrument is liable to pay the penalty, and the amount of the penalty is, first, if the levy is paid not later than 1 month after the expiry of the payment period, double the amount of the levy. Second, if the levy is paid later than 1 month but not later than 2 months after the expiry of the payment period, 4 times the amount of the levy, or third, in any other case, 10 times the amount of the levy. Subsection 2, subclause 2, for the purposes of subsection 1a, if there is more than one transferee under the instrument, the transferees are jointly and severally liable to pay the penalty. Members, Mr. Potham, I'd like to ask about B3. 1B3, 10 times the amount of the levy. That is, in Roman 2, it is 4 times. That immediately jumps to 10 times in Roman 3. That is, for any delay more than 2 months, it will be 10 times. Yes, Mr. Ip's understanding is correct. Other members, any more comments or questions? No? Mr. Wong, please continue. Clause 57 is about certificate of levy and penalty. Subclause 1. This section applies if a certificate is issued under Section 55(1)(b) in relation to a levy and penalty and is served in compliance with Section 55. Subclause 2. Unless the contrary is proved, the certificate is evidence of the fact certified in it in any proceedings. Subclause 3. At any time before the levy and penalty has been wholly recovered, the authority may register the certificate in the land registry against any premises or land in respect of which the levy and penalty arose. Subclause 4. For the purposes of the Land Registration Ordinance, Cap 128, the certificate is taken to be an instrument affecting premises or land and is registrable in the land registry. Subclause 5. On the registration of the certificate, the levy and penalty A is recoverable from a person who from the land registry register appears to be the owner of the premises or land, and B constitutes a legal charge on the premises or land that gives the authority the same powers and remedies in respect of the premises or land as if it were a mortgagee under a mortgage by deed in common form, having powers of sale and lease and of appointing a receiver. Subclause 6. Despite Sections 3, 1, and 5 of the Land Registration Ordinance, Cap 128, if the certificate is duly registered, it has priority from the beginning of the day after the date of registration. Subclause 7. The charge created under subsection 5b is void, and no liability is to accrue under that subsection against a bona fide purchaser or mortgagee of the premises or land for valuable consideration without notice. Subclause 8. On the recovery of the levy and penalty, the authority must lodge in the land registry an appropriate memorial of satisfaction against the certificate registered under subsection 3. Thank you, Chairman. Members, any follow-up or questions? Mr. Wu Chi-wai. Thank you, Chairman. I don't understand something. I'd like to understand more about it. Well, this is about land and premises. Whose land and whose premises? The licensee's land and premises or the land and premises serving him? Well, here it is said that if there's a penalty, a legal charge can be laid on the premises or land. Are you talking about the levy? All right, I understand your point. For the levy portion, you chase after the landlord in the process of sale and purchase. If he refuses to pay, a legal charge can be imposed. Yes, the chairman's understanding is correct. We're talking about levy. All right. Other members? Any follow-up on this clause? Well, one inquiry. Well, if because of this levy, a legal charge is imposed, then if the charge is to be cancelled, who should be responsible for the fees and charges? Thank you, Chairman. According to Clause 8, is for the authority to remove that charge. But of course, before the authority does so, the person has to clear all levy and penalty. Is this the standard procedure? That is, if a charge is laid, then only the authority can remove the charge. That's correct. All right, let's move on. Clause 58 specifies that the authority may recover the amount of any levy or penalty payable under this part as a civil debt due to it. Members, any questions on this clause? If not, Mr. Wong, please continue. Clause 59 empowers the authority to remit wholly or in part any levy or penalty payable for leviable instrument. That's A. Or B. Refund wholly or in part any levy or penalty paid for a leviable instrument. On this clause, any questions? Any follow-up? Mr. Wu Chi-wai? On what basis will the authority make the decision? Any mechanism for the authority to determine whether or not it should remit or refund, wholly or in part, any levy or penalty? Mr. Kwok, well, basically, this is an empowering provision. The authority has the power to remit and refund. The whole levy is based on the stamp duty ordinance. For the vendor and the vendee, an appeal can be lodged on the imposition of stamp duty. As a result, the levy or penalty may have to be remit or refunded. Mr. Chairman, if I understand him correctly, this stamp duty levy is related to the property price. If the landlord says to the registrar that the property price shouldn't be so the stamp duty should be reduced. So as a result, the stamp duty may vary. Well, according to my understanding, that may not be the case. The levy is fixed. Rather, as Mr. Kwok said, the party does not have to pay stamp duty. Therefore, he may not necessarily have to pay the levy. Mr. Kwok can clarify whether my understanding is correct. Chairman, your understanding is correct.
The levy is a flat rate. It is not determined upon the property price. Yes, the ILD may rule that stamp duty has to be paid, but if subsequently it is decided that the transaction doesn't attract any stamp duty, then the levy may also be waived, and will have the power to refund the money to the relevant party. Can you help me to understand under what circumstances will stamp duty not payable? Mr. Kwok, well, I don't have some information with me, but I think for some transactions, the two parties may argue over whether stamp duty has to be paid. I will understand with the ILD to see under what circumstances can this happen. I think such supplementary information will be useful. I cannot think of any scenario where stamp duty is not payable, even in the case of estate or a gift. I think that such scenarios may arise. Let's wait for supplementary information from the administration. After arguments are submitted, subsequently, the transaction may not be subject to any liability to pay stamp duty. But let's wait for further information from the administration. Thank you. Legal advisor. I'd like to ask a question on clause 56, subsection 7. Subsection says that someone who has no knowledge of the charge. Yes, the stamp duty might already be paid before that is done. Okay, no follow-up. If members have no further questions, Mr. Wong, please continue. Thank you. Clause 60. The Secretary for Home Affairs may, by regulation, prescribe the amount of levy payable for a leviable instrument. And B, provide for the exemption of any class of persons or instruments from the applicability of this part, and C, provide generally for the better carrying out of this part. Thank you. Members, any follow-up questions or questions on this? All right, Mr. Wong, please continue. We're now at Part 9, Miscellaneous. Clause 61, Defense for licensed PMP as employee. It is a defense for a licensed PMP charged with a disciplinary offense for an act done or omitted to be done under this ordinance to prove that A, the PMP acted in good faith and in a reasonable manner. B, the PMP did the act or made the omission in the course of the PMP's employment. C, the PMP did the act or make the omission in accordance with the instructions given to the PMP by or on behalf of the PMP's employer in the course of the PMP's employment. And D, the PMP was not, at the time the act was done or omitted to be done, in a position to make an influence a decision regarding the act or omission. Any follow-up or questions? No? Please go on, Mr. Wong. Clause 62. Paid fees not refundable. Fees paid under this ordinance are not refundable. Mr. Wu? Okay, I go back to Clause 61. Can the administration provide information on similar defenses, I would like to look at the provisions. It's not that I have any objection to the content. I just like to have a better understanding of the wording. Yes, we can provide such information after the meeting for members' information. In particular, to a certain extent, decisions are made by owners incorporation or owners committee, so on and so forth. And very often, PMPs are worried that while they have no say on the decisions, they have to be held liable for those decisions. Yes. It says here that the PMP acted in good faith and in a reasonable manner, and that's a defense. The chairman said that in day-to-day management, OCs may engage in rather unreasonable behavior and force the PMP to follow as instructed. Is the PMP required to prove that he has explained really clearly to the OC that this decision is against the law and it would affect the management of the property? How can the PMP prove that he has acted in good faith and in a reasonable manner? Mr. Kwok. I think this issue was discussed earlier on in this Bills Committee. I think when we have code of practice, we will specify how the PMP should tackle the situation. And if such procedures have been taken, then it can be used as a defense by the PMP. So we will be able to see the code of practice to gain better understanding of this matter. Any supplement? That is correct. Okay, legal advisor. In clause 61, PMP has to prove A, B, C, D. That means the onus of proof is on the licensee. What about the standard of proof? Is it just 50-50 or what? Or beyond reasonable doubt? I think the standard of proof should be balanced probability. If it can be proved 50-50 that this is the case, then it is a defense. Oh, okay, no follow-up. Mr. Wong, please go on. Clause 63. Thank you, Chairman. Clause 63(1). The authority may, by notice published in the Gazette, amend Schedule 2. 2. The Secretary may, by notice published in the Gazette, amend Schedule 3. Members, do we have any follow-up or question? Mr. Wong? Mr. Wu Chi-wai? For amendment of Schedules 2 and 3, all these schedules will be amended by negative vetting to enhance efficiency. Well, I'd like the administration to tell us when it comes to actual amendments, because the industry will be affected and the majority shareholder of the property has also got a conflict of interest. While you're going to use negative vetting, you can you specify steps you will take before amending the schedules in the future? As Mr. Wu said, Schedules 2 and 3 will be amended by negative vetting of the Council. But we will not just start the amendment very arbitrarily. It is government's practice to consult with the relevant industry and the stakeholders before initiating an amendment. And I think members will understand that we will have to brief the relevant panel in the Council first, the reasons and justifications for the amendments and views of stakeholders. This is our usual practice. If there are further views, the Secretary has to give them full consideration before amending Schedule 3. Mr. Chairman, I'd like to follow up. When it comes to legislative amendment, will you just require a simple majority support by the authority itself, or will you set a higher threshold? Because these amendments must be acceptable to the authority first before they can be submitted to LegCo. So can you increase the support required in the authority to reflect that the amendment is an important one? Mr. Kwok. I think for Schedule 2, it will be the composition of the authority, and Schedule 3 is about the level or the level of levy. I think due procedures have to be followed to decide that the levy rate is correct before it can be submitted. So there is no need to make it a major resolution, because it will only be moved upon thorough consultation. I will not follow Mr. Kwok Yim's, I will not go by Mr. Wu Chi-wai's proposal. There is no need to require a 2/3 or 3/4 majority. I think a simple majority support by the authority will do. All right, any follow-up? Any questions? If not, Mr. Wong, please go on. Thank you, Chairman. Clause 64. The transitional provisions specified in Schedule 4 have effect. Yes, Mr. Wong, please go on. Clause 65, related amendments. The enactments specified in Schedule 5 are amended as set out in that schedule. Members, any questions or follow-up on the provision? If not, Mr. Wong, please go on. We will now go to Schedule 4, the transitional provisions. Okay. First section under Schedule 4. Provisional PMP licenses. 1. The authority may, on application, issue a provisional PMP Tier 1 license, or B, a provisional PMP Tier 2 license. A provisional PMP Tier 1 license or provisional PMP Tier 2 license may only be issued to an individual. 3. A license issued under this section is not transferable. 4. A license issued under this section remains in force until the end of the period specified in it. 5. The period specified under subsection 4 must not be longer than 36 months, beginning on the date on which the license is issued. Any follow-up or questions on this? Mr. Wong, please go on. Section 2, application for provisional PMP licenses. In this section, officer has the meaning given by Section 2(1) of the company's ordinance. An application for a provisional Tier 1 license or provisional PMP Tier 2 license A must be made within 36 months beginning on the date on which this section comes into operation. B. Must be made to the authority in the specified form. C. Must contain the prescribed information. And D. Must be accompanied by the prescribed documents and application fee. The authority must not issue a provisional PMP Tier 1 license or provisional PMP Tier 2 license unless A. The authority is satisfied that the applicant does not meet all the prescribed criteria for holding a PMP Tier 1 license or PMP Tier 2 license. But 1. The applicant is a suitable person to hold the license for which the application applies. And 2. The applicant meets all the prescribed criteria for holding the license for which the application applies. B. The applicant has paid the prescribed fee for the issue of the license for which the applicant applies. 4. For the purpose of subsection 3A1, in determining whether the applicant is a suitable person to hold the license for which the application applies, the authority must have regard to the following.
該人是否屬職
A. Whether the applicant is a mentally disordered person or a patient within the meaning of Section 2.1 of the Mental Health Ordinance. B. Whether the applicant has been convicted of a criminal offence other than an offence under this ordinance involving fraud or dishonesty. C. Whether the applicant has been convicted of a disciplinary offence or a criminal offence under this ordinance. D. Whether the applicant is or was the sole proprietor of a property management company whose application for a PMC license has been refused or whose PMC license has been revoked or suspended. E. Whether the applicant is or was an officer of or a partner in a property management company whose application for a PMC license has been refused or whose PMC license has been revoked or suspended. Subsection 5. The authority may impose on a license issued under Section 1 of this schedule those conditions, including prescribed conditions, that it considers appropriate. If the authority decides not to issue a provisional PMT Tier 1 license or provisional PMT Tier 2 license, it must, by notice in writing, given to the applicant within 21 days beginning on the date on which the decision is made, A. Notify the applicant of the decision, and B. Give reasons for the decision. Subclause 7. Sections 12 and 13 of this ordinance, with necessary modifications, apply to the holder of a license issued under Section 1 of this schedule as they apply to a license to PMT. Thank you, Chairman. Mr. Ip Kohim? Mr. Chairman, the crux of the matter is was here, whether or not the license had been revoked or suspended. What views did the industry have? Mr. Kwok, are you to answer this? Mr. Chairman, this provision is the same as the one for a standard license. The word was is used. In the consultative committee, we did discuss the requirements and were supported by the members. So this is forever, right? The person involved will never be able to take out a license in the industry, right? Because you use the word was and the expression has been. Well, Mr. Chairman, we did consider the issue concerned. We can consider a longer period of criminal record, and then the party concerned can consider whether or not the criminal record should be considered. We've considered the use of the word may, can, or whatever. So a decision can be made after referring to the duration of the criminal record. Well, my feeling is that this is to apply forever. What happened 20 years ago has to be considered here, because you use was and had been and has been here. So this is forever, right? It's not true that if the incident occurred 20 years ago, there can be a discretion. That's not the case. Well, when considering whether or not a license should be issued, the authority has to give consideration to criminal records, etc. And of course, also what happened afterwards. So a full assessment will have to be conducted to see whether or not the applicant is a fit and proper person. Well, I think they have to put it clearly in black and white. The provision here says that other than blah, blah, blah. And then the word was and the expression has been are used. I don't think the provisions here suggest that a discretion can be made if the incident happened a long time ago. Well, Mr. Ip is concerned about this. His feeling is that the happening would take effect forever. So is that the case? The authority has to take into consideration a number of matters, but that may not necessarily mean that the authority will refuse to issue a license in the consideration of whether or not the applicant is a fit and proper person. Well, Mr. Ip, I think your feeling is different. Well, Mr. Chairman, I think I have to put this in black and white. So what do you mean by was and has been? I doubt whether flexibility is allowed here. So, Mr. Ip, you want a record in black and white? Yes, in future, if there are doubts, we can refer to this black and white reply. All right, after the meeting, we'll give you a written reply. 4C, whether the applicant has been convicted of a disciplinary offense or a criminal offense under this ordinance. This is for a provisional license. Disciplinary offense under this bill or disciplinary offenses under other pieces of legislation. Mr. Kwok? Well, when we consider whether or not the person is a fit and proper person, we'll of course consider whether or not there is a disciplinary offense under this bill, of course. I'll go back and discuss with our law draftsman to see whether we need to clarify this. Well, there is quite a long transitional period during which there may be disciplinary offenses. So please go back and consider this. Mr. Porte, Mr. Chairman, when I read subsection 3, I see something ambiguous. 3A. The applicant does not meet the prescribed criteria, but suddenly in Roman 1, you mention that the applicant is a suitable person, and then number Roman 2, the applicant meets the prescribed criteria. Of course, you are talking about the licensing conditions for a provisional license. Well, on the one hand, you say that if he does not meet the criteria, he shouldn't be given a license, and then suddenly you say that he meets all the prescribed criteria. Do you understand clearly my question? prima facie, this is confusing. On the one hand, you say that if he does not meet the criteria, you won't give him a license. At the same time, you say that if he meets all the criteria, you'll give him a license. Mr. Kwok, 3A said that for a formal license, certain criteria will have to be satisfied, like educational qualifications, years of experience, work of experience, and so forth. The provisional license is to take care of the fact that some industry members may, in terms of regional qualifications or other qualifications, not meeting the criteria for the time being. So the criteria for a formal license may not be met yet, but the authority can issue him with a provisional license. Then in subsection 4, by way of subsidiary legislation, we can set the criteria for issuing a provisional license. So if those criteria are met, then a provisional license can be issued. Mr. Portier, well, that's my guess. Then in Roman 2, should you specify clearly that it is a provisional license? In English, it's just license. I think there may be confusion on the face of it. Well, can you do something to reduce the possible ambiguity? Well, maybe we can go back and consider Mr. Tse's comments. Mr. Portier, any more follow-up? No, just that one. Other members? So, Mr. Wong, would you please continue? Thank you, Chairman. Schedule 4, Section 3 provides that a person aggrieved by decision not to issue a provisional PMP Tier 1 license or provisional PMP Tier 2 license may lodge an appeal. Part 6 of this ordinance, with necessary modifications, applies to an appeal under subsection 1 as it applies to an appeal under that part. On this provision, any follow-up questions? Mr. Ibrahim? Well, no question about the appeal, but what if after the issuance of a license, a landlord or a tenant is dissatisfied? Is there a chance to lodge an appeal? Any such provision in the bill? Well, Mr. Ip, can you clarify what do you mean by the tenant's appeal? On what basis? Well, he considers that it is not correct to issue a license. So you're asking about a mechanism to address dissatisfaction. Well, if the licensee has breached certain terms and conditions, then under the committee's mechanism, a request can be lodged to ask for an investigation into a possible breach. And then it will be examined whether or not any disciplinary action should be taken. Well, when you consider whether or not a license should be issued, understand that committee members may agree or disagree, and there is an avenue for appeal. If you approve an appeal, the property manager can appeal. But what if you have issued a license, a stakeholder queries you why you have issued a license? So is there any mechanism for appeal? Thank you. Well, you have to look at the licensing criteria. For provisional license, the years of work may be involved. Say if the applicant has submitted incorrect particulars, an appeal or a complaint can be lodged with the authority to the effect that the applicant is accused or alleged to have submitted incorrect particulars. As for other particulars not related to the licensing regime, there's no mechanism for appeal. But if there's any breach under this bill, disciplinary action can be taken out to handle the alleged breach.
Mr. Gohim, any from? No? Then Mr. Paul Z. Now for Section 3, I understand that you are talking about any applicant, but the drafting here is a person. Will include anyone who has complained to this PMP before thinking that it is not fair for a license to be granted, or maybe a resident of a particular building may think that it would be too troublesome if their PMC is not granted a license. So can you clarify the wording here so that we know who can be entitled to making a complaint? Next door, we were discussing the mechanism for a private columbarium. Perhaps this is really a rather late stage, but is it really appropriate to use a schedule to set out the mechanism to be used by a regulator? Because for the bill on private columbarium, they use the principal ordinance to deal with the appeal mechanism. But here, this is in the form of a schedule. All the provisions are related to the licensing body can be amended by negative vetting. Well, I saw the administration shaking their head, but one is to include this part in the principal ordinance, the other is to include in the schedule as you do it now. Have you considered the perception of the industry and whether you are giving them sufficient protection? Mr. Lam? Well, Clause 63 says that Schedules 2 and 3 can be amended by notice in the Gazette, but to amend Schedule 3, it must be in the form of a bill. And what about making it clearer to say a complainant instead of a person? Mr. Cotham, the administration said that this is just a provisional PMP license. What about a proper PMP license? Will there be any appeal mechanism? If it is just provisional license, it is acceptable. The appeal mechanism deals with factors for considering an application. And when it comes to actual license or the formal license, we'll consider the professional qualifications, the years of service, whether he is a fit and proper person, whether he has any criminal record. So even under the appeals mechanism, only appeals in relation to these four factors can be handled. Now, if a person feels aggrieved, if his application for a license is refused, then he can make an appeal. But if another person is not happy with the granting of a license to a certain person, then he can also make a representation to the licensing authority in the form of a representation, not an appeal. Yes, a representation. He has to explain to the authority why it is problematic to give a license to a certain person, and the authority will decide whether investigation is warranted using its own powers and whether the person has done any inappropriate acts. But perhaps right from the beginning, the person has really set out his views, but the authority feels that it's still okay to give that applicant a license. And if the first person is not happy with that decision, he may want to lodge an appeal. Is it true that he cannot make any appeal? Well, in considering an application, we have to consider the professional qualification, the education qualification, his years of experience, and whether he's a fit and proper person. Only these factors will be considered by the authority. If, however, residents think that he did something wrong while managing another housing estate, that is not one of the considerations in examining an application. So for the licensing criteria, the authority will only consider these 4 factors, and appeals can only be entertained if they are based on these 4 criteria. People with different views will be tackled differently by the authority using another mechanism. Well, Schedule 3 is about the whole licensing regime, and my observation was the whole regime mechanism are included in the schedules, whereas for private current barrier, the whole mechanism is regulated in the principal ordinance. I'd like to know whether this is a considered decision by the administration to have different treatment. So you're not just referring to Schedule 4? Well, yes, Schedules 2 and 3 as well. Thank you. The major provisions of the authority is included in the principal ordinance, but for other operational details that is included in the schedule, we have similar arrangement in other pieces of legislation, such as the competition ordinance. The principles are in the principal ordinance, so that the provisions can only be amended by an amendment bill. But for other technical provisions, operational details, they are included in schedules, and they can be amended by subsidiary legislation. So this arrangement here is not really rare. I know there are precedents, but I'm asking, how come for private column barrier, we deal with the whole mechanism in the principal ordinance, and whereas here we have included it in Schedule 3. Of course, I get your point. You're talking about the administrative details. But what about the composition of the authority, appointment, and everything important is in the schedule? In fact, these matters are quite significant. Are there any special considerations, Mr. Kwok? Different policy bureaus may have different considerations, even for different pieces of legislation. So for composition of this bill, we have made reference to the arrangement of similar authority or public bodies, and we believe the current arrangement is appropriate. Any further questions on this? If not, Mr. Wong, please go on. Section 4. Thank you. Schedule 4, Section 3. The authority may, by regulation, prescribe A, the information to be contained in and the documents to accompany an application for a provisional PMP Tier 1 license or provisional PMP Tier 2 license. B, the fees payable in an application for a provisional PMP Tier 1 license or provisional PMP Tier 2 license. C, the criteria for holding a provisional PMP Tier 1 license or provisional PMP Tier 2 license. D, the fees payable for the issue of a provisional PMP Tier 1 license or provisional PMP Tier 2 license. And E, the conditions that may be imposed on a provisional PMP Tier 1 license or provisional PMP Tier 2 license. 2. The criteria mentioned in subsection 1C. A, may include criteria relating to the applicant's academic qualifications, professional qualifications, and relevant work experience. And B, may impose more stringent requirements for a provisional PMP Tier 2 license. Members, any questions on the provisions, please? Legal advisor. on disciplinary matters will be included or added to Schedule 4. Can you please repeat? Disciplinary. We were told that for disciplinary matters, the provisions would apply to provisional licenses as well. Mr. Lam, I will discuss with the law draftsman as to where we should add these provisions. Any follow-up questions? Now, if there are no further questions, the time scheduled for this meeting is up. The administration would like to complete Schedule 5 as well. Members, I have no objection. Well, if it can facilitate members, I can stay on. Then we may have to extend this meeting. Of course, we've scheduled another meeting for the 6th of July at 4:30 on Monday. So why don't we leave it to the next meeting? Because members have raised questions, and I think such questions should be discussed at the next meeting. I hope the administration can provide written replies to the questions asked by members. As I said, the next meeting is scheduled for the 6th of July at 4:30. If there are no AOB items, the meeting is adjourned.